Don't end up in probate because of your bank account. Now, probate is what occurs when somebody has died. The will gets filed with the court, or if they have no will and there's no other plan, then the probate court will still deal with what to do with somebody's estate. Now, most times people will either set up their estate plan knowing that they want to probate because it is a very valuable tool. For example, at ELG Estate Planning, we often will work with clients to set up an estate plan that will go through probate. Why? Because we're going to protect half to 100% of their estate from other threats. On the other hand, if that isn't their situation or their goal, the client just wants things simple. Let's say that they want to avoid probate through use of a revocable living trust. We will create an estate plan that avoids probate by using a revocable living trust. But keep in mind that if you have a revocable living trust, all your assets that can be titled in that trust should be titled in that trust. So if you forget a bank account because maybe you had everything set up appropriately and then there was this teaser rate on interest at the bank and you didn't set the bank account up in the name of the revocable living trust, it's only in your name, that might require a probate because of that one bank account. Or maybe your estate plan is really simple. You have a will as a backup, but you just want to avoid probate by pay on death provisions. That's like beneficiary designations of what the bank account is. And that is how it's set up. So you have everything set up appropriately. Pay on death to, let's say you have 3 kids, to your 3 kids. But what happens? Maybe you lose capacity and then your attorney-in-fact comes in and then maybe they don't understand as well what your plan is and then they see the possibility of a higher interest rate at a different bank or in a different setting up the new account, and they forgot to do the pay on death provision even though that was your plan, but you know, the ball got dropped, and that does happen. So oftentimes we will see a probate required because of one bank account. What can you do to make sure that that doesn't happen to your estate? Certainly follow the rules, the guidelines that your attorney gave you, but really reach out to your attorney every now and then to say, now, can I sit down with you and talk about how my estate plan is set up, because I want to make sure that I understand it, or I want to make sure my attorney, in fact, the person, the agent under the durable power of attorney, understands it too. Your attorney should be your resource. They should be your guide. And if you find that your attorney is not available to help you, well, maybe it's time to find a new attorney who will be there for you.